Okay, thank you very much once more, Mbak Raka, for a great welcome for everyone, and once again for Professor Newman. We're really happy and very, we in Indonesia, we have a word semangat, which is quite encourage ourselves because we face and having a great class today for discussing a great also theme of seminar. And for everyone also, once again, I would like to say good morning from Indonesia and good evening probably in Canada and also Australia. And today, based on our title, we going to have a Kuliah Umum or public lecture about Indigenous people, focusingly about Indigenous people rights protection and how we compare between Indonesia and Canada. And my name is Indra Waspada. I am right now a master student as introduced by Mbak Kaka. And I'm graduated from undergraduate adat law department in Universitas Gadjah Mada. Okay, a little bit description about today's activity. I will continue to the rincian kegiatan or the flow of today's activity. So it will be opened by Mbak Kaka and us, and also, I'm sorry, it will be opened by Mbak Kaka and me, and then it will continue to the Professor Dwight Newman lectures, which he will talk about Indigenous people legal protection in Canada, and once again, it will be present another lecture which has the title Indigenous People Legal Protection in Indonesia, and then the Q&A, and then there's a little bit explanation on pengumuman terkait perkuliahan. And then it will be closed, and yeah, it's going to be full flow of today's activities and seminar. So to shortening our time, the next part would be opening from Mbak Kaka as one of the member of Department Adat Law in Universitas Gadjah Mada. Mbak Kaka, floor is yours.
Okay, thank you, Indra. So I'm so grateful that we can gather together today in our first class, the public lecture, Comparative between Indigenous People Protections from Canada perspective and as well as from Indonesian perspective. And we are also honored with the willingness of Professor Dwight Newman to share his experience with us about Canada's legal protections towards Indigenous people, as well as there is lectures also from Faculty of Law Universitas Gadjah Mada, my senior, Bapak Sulastriono. He is our senior lecturer in Department of Adat Law, Faculty of Law Universitas Gadjah Mada. And also welcome for all of the students. This is a very good opportunity for us to learn how not only in Indonesia, but also in the Canada's perspective, how Indigenous people are protected. So let's study together, and I hope it will be a very fruitful discussions. Thank you, Indra.
Thank you very much, Mbak Kaka. Okay, everyone, once again, give applause to Mbak Kaka. And now, before maybe we starting our lecture, public lecture, I will read a little bit about tata tertib or guidelines for today's Zoom for make sure everyone are comfortable and focused enough to have this class. Okay, number one, when joining via Zoom, please everyone keep the microphone muted to prevent background noises. You can unmute during this designated speaking times for this. And for those people on YouTube, please engage through the comment section to interact with others and moderators. And second one, use the chat feature or raise your hand for questions or comments. We'll address them during Q&A. And then number three, maintain focus and respect during the presentation to maximize learning for all participants. And lastly, if you encounter any technical issue or you want to ask directly questions during the presentation, you can give it in the comment sections and we will talk later on Q&A. And feel free to message in the public general chat or through my personal chat in this chat rooms. Feel free to message the moderator privately to assistance. Okay, let's continue now to the main part of this seminar, which is Professor Dwight Newman. He will introduce and give us a lecture about Indigenous people legal protection in Canada. Maybe before Professor Newman will give the class, I will share a little bit about his curriculum vitae. Professor, excuse me to explain a little bit about Professor. So, Professor Newman, ladies and gentlemen, we are very privileged to welcome him, a distinguished figure in realm of Indigenous rights law from the University of Saskatchewan, with an impressive academic background, including a DPhil from Oxford, as a Rhodes Scholar, and a wealth of professional experience ranging from clerking at the Supreme Court of Canada to global human rights advocacy. Professor Newman brings a depth of knowledge and insight. His prolific contributions, over 100 articles and 15 books, have been pivotal in advancing an understanding of Indigenous rights, notably through his work on the duty to consult, an Aboriginal title. For students in here, also scholars in YouTube and legal professionals also joining this seminar, learning from Professor Newman's research is very valuable for us, including Indonesia as a very rich in the issue and also conversation about Indigenous people. So as we proceed with today's seminar, Professor Newman's expertise will illuminate, of course, the critical aspects of Indigenous rights, offering perspective that's crucial for us. Okay, very great welcome and give a little bit applause with emoji from all the people in here. Please join us warmly welcoming Professor Dwight Newman. Good morning once again, Professor from Indonesia, and good evening.
Good morning. Yes, and I'm very honored to speak with you, and I'm very glad to have the opportunity to share some experiences and impressions as between Canada and Indonesia. I think these sorts of international dialogues are occasions for all countries to learn from one another. And I hope I'll share some things that may be of interest in Indonesia, but also hope to learn some things that would be of interest to Canada as well. And so I'm going to speak relatively briefly. We had agreed upon relatively brief presentations in order to leave room for time for discussions and questions. If I can put up my PowerPoint presentation successfully, which I don't always do PowerPoint presentations, but I did wish to do so for this. You should be able to see the PowerPoint presentation that I'm putting up in order to just to give an outline of what I will be talking about in relation to Canada. But I just express my deep appreciation for this opportunity to participate with you and with all of you in this discussion, and look forward to our discussion. I come from the University of Saskatchewan in Canada, although I'm currently on an academic sabbatical, and so I'm actually speaking to you from the University of Queensland in Brisbane, Australia. But in Canada, when I'm at the University of Saskatchewan, we're in an area called Treaty 6 territory and the homeland of the Métis. It's an area under one of what we call the numbered treaties with First Nations peoples, and I'll talk about that a little later on. But I got involved in, well, I work a lot on constitutional law and on Indigenous rights law, and got involved in Indigenous rights law because it addresses some of the deepest moral questions that Canada has to face up to in terms of its colonial past and how it responds to those historical injustices in the past and ongoing difficult situations for Indigenous peoples in Canada today. So in thinking about comparisons between Canada and elsewhere, each place has its complexities, and just how Indigenous rights are applied in each country is going to be affected by some of its context, even when we're sometimes talking about international Indigenous rights. So in terms of Canadian Indigenous and colonial history, I'm speaking very simply of some complex things, but I'll just highlight that Canada, like Indonesia, is a large country, geographically large. Canada is very geographically diverse, with areas from relatively temperate regions on through to very cold Arctic regions. And most of Canada gets cold in the winter, but not all of Canada. The West Coast actually stays quite warm even in the winter. And so different Indigenous peoples historically had adapted to different territories within Canada. And I think that sometimes lines up with measures of cultural diversity. There are some values sometimes that appear to be shared across different Indigenous peoples, but there are also other perspectives that may be different amongst different Indigenous peoples. And it's very important never to homogenize all of the Indigenous peoples in Canada. There are many Indigenous languages within Canada, and many different Indigenous cultures within Canada. Today, Indigenous peoples are about 5% of the population of Canada. There's been a great deal of colonial settlement that took place, but there remains this diversity amongst those Indigenous peoples. So there are in Canada 600 plus First Nations, and that would today be the term usually used for First Nations communities that in the past were sometimes called Indian communities. That didn't make sense. It related to some confusions on the part of early European explorers who thought they had gone into India, and they hadn't. They were encountering different peoples. So 600 plus First Nations communities who historically were grouped sometimes in different nations, so a smaller number of nations perhaps, but have been subject to a division of governance through the colonial period. So there are actually 600 plus First Nations today, with linkages amongst some of them, but not amongst others. In addition to First Nations communities, there are Métis communities, and Métis communities in Canada come from an ethnogenesis that took place after European contact. So some early European settlers ended up in mixed marriages with members of First Nations. And most Métis communities are French descended. And so French settlers ended up in mixed marriages, but that gave rise to separate communities that developed their own cultural contexts. And so today continue as Métis communities that are also Indigenous communities, but with a different ethnogenesis that took place early on. And then there are also in Canada the Inuit, who are a people of the north of the Arctic, and who are across the Canadian Arctic, although there's one particular territory in the Eastern Arctic that's been established as having a public government that would be majority Inuit. That's a relatively new territory within Canada called Nunavut. But under the Constitution and under international law, First Nations, Métis communities, and the Inuit all have Indigenous rights. So that's part of the complexity, is the range of Indigenous nations about which we're speaking. Add to that complexity that there's been colonial settlement in Canada by mainly the French and the English at different points in time in different parts of the country, and then ultimately an English takeover of the French colony through military conflict. So the French colony is what is now the province of Quebec. And because of differences amongst the colonial governments within Canada, we have a system of federalism where the provinces actually have quite a few powers, although there's also a strong federal or central government. And that adds some complexities as well. While the federal or central government has a particular jurisdiction in relation to policies affecting Indigenous peoples under our 1867 Constitution. The provinces have many legislative powers that impact upon Indigenous peoples. And so there's a complex division there. I won't go far into that because that would take us into another topic, but we could talk more about that if that's of interest at some later stage. So I'm going to talk about things briefly pre-1982 or before 1982, and then I'm going to talk about a major change to protect Indigenous rights since 1982 as one important historical moment in Canada. And time will go fast, so I'll move along. I'm going to talk very briefly about the pre-1982 protections, and I'll say there were historic treaties reached with Indigenous nations from the mid-1700s through to 1921. And so we use the term historic treaties as a technical term because these are older treaties. They took slightly different forms in different parts of what's now Canada, and they have some different clauses within them. The Victorian or numbered treaties from approximately 1870 to 1921 have a great deal of commonality. They govern a lot of Western Canada, but a lot of Canada further to the east is under earlier treaties, and this reflects when colonial settlement was taking place. And then as another technical term, we have so-called modern treaties from 1975 onward. And modern here isn't meant to be any kind of a judgment or historic versus modern, just refers to the time period. But there are some different characteristics to the modern treaties. They've typically been much more detailed treaties negotiated with lawyers on both sides. And in the context of contemporary Indigenous rights claims, where the historic treaties tended to be briefer and were in a context with a complex, unequal bargaining power. So they continue to provide important protections, but there's a different context each. Canada is a common law country, like England, so it followed English common law in some respects and then gradually adapted that. Under the common law, courts actually started recognizing some Indigenous rights, and there was a very significant decision in 1973 in a case called the Calder decision from the Supreme Court of Canada, which in principle recognized Indigenous land rights under the common law as something that, upon certain criteria being met, would actually be recognized within the common law. Now, you might actually note that the modern treaties period commencing in 1975 is actually something that started shortly after 1973. The Calder decision prompted governments into trying to settle a number of outstanding land rights claims that weren't receiving attention before that. So it's an example of the common law courts pushing governments along in some ways. But pre-1982, the story actually isn't very positive for the most part, and there was largely a lot of paternalistic policy by the federal government under a piece of legislation called the Indian Act, under the old name of First Nations. There were a lot of interferences with Indigenous nations, interferences with Indigenous families. Canada went through a period in which many Indigenous children were removed from their communities and taken away to residential schools. And it's a historic period we're now looking back on and trying to overcome in various ways. And there was a Truth and Reconciliation Commission that looked into what went on with those that reported back a number of years ago, and interferences with Indigenous individuals who were subject to a lot of restrictions. So pre-1982, there were a lot of challenges. 1982 didn't magically resolve things, but there was a significant change when Canada updated its constitution in a number of different ways. The particular test has received a great deal of criticism as not being sufficiently protective of Indigenous communities, but it's something that wasn't there before. And then in a case the following year, the Delgamuukw decision, the Supreme Court of Canada recognized land rights as constitutionally entrenched. So beyond the Calder decision I mentioned earlier in 1973 under the common law, now in Canada, Indigenous land rights, where those haven't been resolved through treaties, land rights claims can be taken to the courts. But there's a very challenging process to actually take those claims to the courts. The Sealco team decision from 2014 was actually the first time that a court awarded specific lands in response to such a claim. But these cases have supported the negotiation of some modern treaties with land rights recognized within those. In addition, the courts have developed a doctrine called the duty to consult, sort of a set of legal rules that require governments, the federal or provincial governments, to consult with Indigenous peoples before making decisions that affect their Aboriginal rights or treaty rights. And so that's actually been a very significant protection in some ways. It receives, to be fair, some criticism as not always being effective, but I think it has had a great deal of a very significant set of effects. Now, I've written 2 books on the duty to consult doctrine. I'm seen as somebody who's seen it as relatively effective, and not everyone shares that view. I'll say that, to be fair. But it is something that has changed a lot of government policies and has seen a lot of consultations take place. The one other piece I'll mention is that in recent years, and I'll say in the last 5 years, there have been tentative steps by some courts to recognize Indigenous law, especially in the Federal Court of Canada. There have been some court decisions that have said that the law of Indigenous nations themselves is part of the law of Canada, and something that has recognition in Canadian law. Now, we're not very far in that process, and I want to be clear there that I don't think Canada has lessons to offer yet on that. It might actually learn from elsewhere on how better to respond to legal pluralism, but the courts are starting to do so, and I think affected by Section 35 in doing so. My time is going to run out quickly, but I'll just say that a significant step in recent years, or a significant set of steps, have resulted from the United Nations Declaration on the Rights of Indigenous Peoples. So international norms are
challenges, contributing extensively to our understanding of indigenous and traditional rights within Indonesia's dynamics legal framework. Her scholarly work, which spans the empowerment of marginalized communities, the historical underpinnings of maritime law in Indonesia, and the vital role of pluralistic legal approaches in understanding adat law, positioning her as the essentially voice in the discourse on legal pluralism and indigenous right protection. Okay, as we delve into the topics, we probably and mostly will have a lot of questions about her works, about her presentation later. And once again, to shorten the time, please join me in extending a warm and enthusiastic welcome to Mbak Kaka, Mbak Sartika Itanding Pradani. Good morning, Mbak Kaka.
Am I audible, Indra?
Yes, Mbak Kaka. The presentation already shown also. Okay, Mbak Kaka, now the time and floor is yours.
Okay, thank you very much, Indra. From Professor Dwight Newman's presentations, he point out that history plays a very important role when we understand how, at the current situations, Canada face a challenge on how to protect Indigenous people rights. What about Indigenous people protections in the Indonesian context? This is Indonesia. So Indonesia is, we all know that this is in the Southeast Asia. So what we call as Indonesia as a nation state is basically started from the 19th 1945. So before 1945, what we know about this territory was not Indonesia, it was the Dutch colonialist Indies or Hindia Belanda. So we just recognize that Indonesia as an independent state is since 1945. And then before we start about how the legal protections towards indigenous will a little bit move to the history during the Dutch colonial government. So if in the context of Canada, like Prof. Newman have just mentioned, they mentioned those indigenous people with different names, like the First Nations. Meanwhile, in the Indonesian context, they were called as pribumi initially. And then the law applicable to the pribumi people or the native people in English, Van Vollenhoven, so this is a Dutch legal scholars, which is the customary law scholars. So now we call the customary law in Indonesia is adat law. According to Van Vollenhoven, the law applicable for the natives consists of the adat law and then the codified law. While the adat law itself, it consists of indigenous law, which has been influenced by the religious element. So from this perspective, we can see that since the beginning or since the Dutch colonial government, Van Vollenhoven introduced adat law to not to distinguish the indigenous law from the religious elements. So Van Vollenhoven has aware that indigenous law has been influenced with religious element and it's called as adat law. So within the adat law itself, there is a religious element. We can see up until today, like in the practice of Minangkabau people, which are strongly influenced by Islam, as well as in Bali, for example, where Indra Waspada lives, it's strongly influenced by Hindu. But then what is applicable for the adat law community or the indigenous people, we can call them indigenous people, not only the native law, but also the codified law, which is the law made by the colonial government. So that's how we see by the history that there are several laws or legal pluralism exist. That's why Penda Beckman said that when Van Vollenhoven, as a Dutch legal scholar, introduced what we call as adat law, it does not necessarily to construct adat as law in the positivistic legal approach perspective, but it's more too easier to talk with the legal scholars that the native people or the adat law community or the Indonesia or the indigenous people, they have already had their own rules living with them. So basically, when we talk about adat law, we will talking about three concepts which strongly support the lift of the adat law community itself or the indigenous community itself. It consists of in Dutch called as beschikkingsrecht or the rights over land and territory. Rechtgemeenschap, this is like as a community who has the authority to create the law, as well as the adat law itself or the customary law itself. So the law which regulates what should, how the management of the territory should be conducted. So we talk about this. Initially, it was talking about the beschikkingsrecht. It's in Dutch language or in English. This is the sovereignty or autonomy or ability of the adat law community as a self-organizing community. So the community is considered as the ruler or as the owner of its territory. So the importance of introducing the adat law and the indigenous people is actually this the effort or Van Vollenhoven in order to resist. So there is the nature of struggle, resistance against unifications because native people have their own law, and then because second, the implementations of European law to native people had proven broad unfavorable impact. And then when we talk about this beseeching recht, this is not only the rights of the community as a union of a community, but it's also, we are talking about the individual rights of the member of the community. So the implementations of the beseeching recht has two natures. The first is the community as a legal subject, and then as well as the rights of the members of the community with the partial lands or natural resources within the community itself. So since the Dutch colonial government, we have already aware that in the context of Dutch East Indies or Hindia Belanda, there is coexistence pluralistic land tenure system, where the state has its formal state land tenure system, as well as the Adat community or the indigenous people, they have the informal, customary, or indigenous land tenure system. And the interactions between them are dynamics, not only conflicting, but also in some other cases, they can accommodate to one another. So this is like the several characteristics of the informal or customary or indigenous land tenure system. One of the things which is very unique is there's religious magic or supernatural power as creator and owner, as well as the nature is communal, and then mainly the evidence is unwritten, and then it's not basically, it's also can grant the rights to the outsider to have particular rights towards the natural resources within the authority of the community. So that was basically what we talk about the rights of the indigenous people towards their land and territory during the Dutch colonial government. Now we will see during the Republic of Indonesia. So we see that in the context of Indonesian's government, we can classify into three different order or period of time. The first is in the 1945 to 1965, we call this order or early independent. This is during the Sukarno's era. And then the new order from 1965 to 1998, this is during the Suharto's era. And from 1998 up until today, we often call this as Reformation's era. So we will see that the beseeching recht, which already recognized since the Dutch colonial government, it still become an issue when it is being recognized by the Republic of Indonesian government. So the beseeching recht, basically, there is no official translations, but according to the basic agrarian law, it is proposed to be translated as ulayat rights. Meanwhile, basically, ulayat rights is only an example of beseeching recht. So ulayat rights is an example of beseeching recht in the Minangkabau community. So Minangkabau is in West Sumatra. So the beseeching recht, which previously considered as rights or autonomy or even sovereignty, the authority to regulate rights in the hand of the community, not the members of the community, which then from these rights, the community has the authority to create legal rules to regulate the ownership, the use, and utilizations of land and natural resources. So this is like the previous idea of beseeching recht. But then it is being reduced, the concept of beseeching recht into the which partial of land which can be authorized by the indigenous people as legal as a community, and which land can be authorized by the indigenous people's members. So it is limited to the partials of land instead of perceiving the beseeching recht or ulayat rights as an authority. So that's being criticized by Susangopeng. And then we see that in the old order, the indigenous people, there are like if Prof. White have just mentioned, like there are 600 more First Nations. In the context of Indonesia, it was found in the early independence, there are more than 250 zelfbestuurende landschappen and volksgemeenschappen, which then recognized by the state as the existence of territorial adat law community structure. And then the structure is being recognized as part of the local government in three different level, and the lowest one is village, nagari, or marga. So what we call as village, nagari, or marga, basically they are the territorial indigenous people. But then it's being weakened by the existence of Law Number 1 of 1957, where village is no longer recognized by the unit of regional government. So in the early Indonesian independence, there was an idea how to integrate the indigenous people community within the state legal system as one of the part of the regional government. But unfortunately, the idea of integrations by recognizing the ulayat rights of or the speaking rights or the autonomy of the community towards their society is not further recognized during the new order. The constitution remained the same. The basic agrarian law, which recognized the ulayat rights, remain the same. But according to the local government as well as village law, the village is being unified or equivalently recognized as region or district. And village itself was considered not as those native people, but more those people who living with feudal values, because that's why they are living with the colonial oppressions and exploitations. That's why they should be changed, they should be reformed, and they should be unified. This weaken the authority of the adat law community towards their own territory. So it was very oppressive regions at that time. And what happened today, like during the Reformations era, there is a significant change, especially in the constitution. So we got three amendments of the Indonesian constitutions since 1998, 1999, 1990, 2000, and 2001. So now we have the protections toward the indigenous people in constitutions. We can see that the state recognized the adat law community and their traditional rights, as well as respect cultural identity and the rights of the traditional community. The basic agrarian law remain the same. So in the context of Indonesia, we do not have like, first, we do not ratify UNRIP, which has ratified UNRIP, and there is no like a single law which protect all the rights of indigenous people, but the rights of indigenous people are protected by scattered law and regulations. So it's like sectoral, depends on which rights it's being protected. For example, in the context of land law, it's in the basic agrarian law. In the context of forestry law, it is in the context of forest, it is protected by the forestry law. And then in the context of waters and coastal areas, it is protected under the coastal and small islands management law. So it is scattered. This is in the national level. Not only in the context of regulations, it is also in the context of decisions. For example, there is Minister of Environment and Forestry decisions about the recognitions of adat forest in Bulukumba Regency. In the local level, recognitions of the indigenous people can be conducted by the local government, either in the provincial level or in the regency or municipality level. Like an example is the regional regulations, recognitions and protections of Amatoa Kajang Adat Law community. And also after the reformations, there are several new state institutions, as well as the institutions have like specific duties. One of them is constitutional court. The authority of the constitutional court is to conduct judicial review when law is in contradictions with the constitutions. So, according to the protections of indigenous people, there was a judicial review brought by the indigenous peoples as well as the fishermen. They argue that forestry law, which defining adat forest as state forest within adat law communities territory, is against with the recognitions of adat law communities' rights and as well as their traditional rights. So they brought this to the Constitutional Court, and then the Constitutional Court granted their petitions, and then the Constitutional Court in 2012 declared that adat forest is not part of the state forest. Adat forest is within the territory of the adat law community themselves. It also happens with the fishermen, so the adat law community living in the coastal areas. They argue that the rights to cultivate coastal water is against their rights because it is limited by time and territory. That's why then it is being revoked by the Constitutional Court decisions in 2010. Not only Constitutional Court, it is also possible to bring the cases where local regulations against the law. It can be brought to the Supreme Court. As well as there are several cases, like in individual cases, especially in the context of decisions, it can be brought to the administrative court or in the district court in the local level. So now, like we see that protections toward indigenous peoples are protected not only by the law and regulations, but also by the court. And then thanks to Indra, he has been shared that now we can see that in Indonesia has identified there are more than 200 adat law community. As well as we can see that the recognitions toward indigenous people as well as their territory has been quite better being identified than in the previous situations. So now, hopefully, with all of these legal protections, it can bring justice, it can bring legal certainty towards the rights of indigenous people in the Indonesian context. So I think that's all my presentations. Thank you very much.
Thank you very much, Mbak Kaka. Once again, give a really big applause by the emoji applause on Zoom to Mbak Kaka. It's really, once again, insightful, and for maybe people in here that have concentration in adat law has already a little bit known a little bit about this information, but for people who really interested and know more about adat law and how protection of adat law community is really informed very informatively by Mbak Kaka. And one great points that I can see from Mbak Kaka and Prof. Newman presentation is how each country has their own way to recognize the protection of indigenous community and their rights, but they also have some certain problems and issues that faced by the indigenous community and perspective also from the countries that give the protection itself. Okay, I think we already have a couple questions already from all of the attendees and friends in here. So maybe we can directly in the Q&A sections. So later, Prof. Newman and Mbak Sartika can answer these questions. And for people, attendees in here, once again, if you want to ask directly, you can hands up, you can raise your hand. And for people that already sent questions, I will call the name and you can ask directly. Okay, while waiting for people to hands up, I will read one question from one of the attendees in here, and we'll call the name. Okay, this question from Avicenna Alang. Is Avicenna Alang in here? Avicenna Alang, Chandra? Okay.
Yes, he is here.
Okay. Okay. You sent the question, right? If you want to ask directly, you can ask right now. Can you turn on the camera and the mic, Alang? Okay. Okay, Alang, already here. Okay, Alang, as you already sent the question, it's better if you ask directly, and yeah, you can have your time.
Okay, thank you. Uh, before I start with my question, I'd like to say sorry because my pronunciation is a little bit bad. So I hope you can know what I want to ask about. Okay, Indonesia recognized indigenous land protection on Law 5, 1960, or often called UUPA, Undang-Undang Pokok Agraria. It states that the nation recognizes Ulayat rights as long there's no contradiction between Ulayat rights and the nation law. Under the Jokowi's regime, there's a thing called PSN, Proyek Strategis Nasional. And then indigenous land in Indonesia are being threatened under PSN development. I'd like to know how customary land protection in Canada under the government project for development. Thank you.
Okay, so once more, Alang, ask both. Probably this question may be more likely to be answered by Professor Newman, but if Mbak Sartika has also a little bit answer about it, it's feel free to answer. So basically, it's about how Alang asked how customary land protection in Canada under the government project. For example, in Indonesia, as he said about laws, he said about contradiction between Ulayat rights or the law of the indigenous people land and the national law. So there's some sort of like issue and how the nation of focusing more in the national project over the indigenous people land and rights. How about the Canada how is the issue in Canada and how basically customary land protection in Canada if there is a government project on the land? Okay, Professor Newman, time is yours to answer.
Okay, and thank you for the question. Your pronunciation was wonderful, and your English is wonderful. And I'm just sorry I don't speak Indonesian because it's a very large country and a language that should be spoken more. But obviously we are proceeding in English today. And but I would just say that the answer to this question is complicated, and I was struck by one of the points in the presentation about Indonesia that referenced the idea that there isn't one single law for all rights, but that indigenous rights are protected by a scattered set of laws. And I would say the same is actually true in Canada, even where there are certain overarching constitutional rights, or where there are statutes about the UN Declaration on the Rights of Indigenous Peoples. Actually, a lot is about what's happening under individual statutes. And so how government decisions about resource development are affected by customary indigenous land rights can vary depending on in what province this is occurring or whether it's something that's under federal jurisdiction. If there's an established indigenous right to the land that would be recognized in the courts, where it's actual ownership, then that would actually mean that the Indigenous community needs to consent before that development could go ahead, or there would be rare circumstances in which a landowner's right could be overridden, but sort of with tests about whether it's permissible to expropriate, and they get quite difficult. So the basic requirement, if it's an established right, would be a requirement of consent. What's more complex is that often we're talking about rights where there's a claim, and not everyone is in agreement on that yet. And in those cases, different statutes approach that differently. And there's also this general constitutional requirement about consulting with the Indigenous community and complicated things that come from that. And so it really depends on a lot of factors. And where there's an established clear right of ownership, there's quite a bit of protection. Where there are ongoing differences on whether the right is established or not, then things get more complicated, and they depend a lot on the particular statutes and the particular evidence that can be put forth for the claim in the context of an argument about consultation. So I'm sorry not to be able to give one clear answer, but that would be a best attempt at describing it as simply as possible.
Thank you very much, Professor Newman. Okay, from Mbak Kaka, is there any points that you want to add?
Yeah, I think Alang has already been understood how in Indonesian context works. So it's nice that we got further explanations in the practice of Canada. So maybe if Alang has further questions, you can just offer it to him.
Is it all correct? Is it all right, Alang? Okay, I think it's already answered all of his questions and thought. Okay, we have one more person direct message me, want to ask directly. But before Dylan, please prepare after Timothy. Okay, so now is Timothy. I want to remind you can turn on your camera and mic. Timothy sent me one question, but if you want to ask directly to the lecturers, you can ask. Okay, Timothy already here. Timothy, time and floor is yours.
Good afternoon, everyone. I would like to state my question to Professor Newman. It's about how can Canada strengthen and enhance legal frameworks to better protect the rights and sovereignty of Indigenous people, and ensuring effective mechanism for consultation, consent, and meaningful participation in decision-making processes, particularly in matters related to resources development and land use. Is my question based on my observation on your presentation, Professor. I would like to know the answer. Thank you.
Thank you very much, Timothy. Okay, Professor Newman, you can answer the question.
Okay. I mean, how can Canada strengthen its framework? I think there are ongoing steps in that regard. And I think that one of the sources that's helping Canada a lot is the engagement with the United Nations Declaration on the Rights of Indigenous Peoples, but also the engagement with Indigenous nations themselves within the territory that's now within the Canadian state. There's an ongoing process of dialogue, and in various smaller ways, bit by bit, Canada is gradually strengthening its framework on Indigenous rights, but that's a gradual process in some respects. In terms of mechanisms for consultation, consent, and participation, I think you've identified some keywords there, that there is a bit of discussion of how to move from an approach oriented to consultation as under the Canadian Duty to Consult framework to one that more and more embraces the idea of free, prior, and informed consent, or FPIC, by Indigenous peoples. And it remains to be seen exactly what form that will take, but the idea of seeking consent from affected Indigenous peoples, as opposed to just consultation, is one of the key ideas that's been under discussion, and that's motivated in part by the United Nations Declaration on the Rights of Indigenous Peoples. So I think in working together, in making various gradual reforms, Canada is working to strengthen its framework, more so than that there's one simple overarching answer in that respect.
Okay, thank you very much, Professor Newman. How is it, Timothy? Do you have any further follow-up questions?
Actually, that's quite clear. Thank you, Professor and Mas Indra and Mbak Sartika, for the materials that you've been given to me. Thank you.
Okay, thank you very much, Timothy, for the time. Professor Newman, I would like to call another attendee that already asked the question, Dylan Andrian.
Hi, sorry. My camera's not working for some reason, so would it be all right if I asked without turning my camera on?
Yeah, sure.
Okay, so sorry about that. I have a question for Professor Newman. I remember in like 2022, I think it was, the Canadian government recognized that it had committed genocide against the Indigenous population. And what I was interested in was, I think a lot of the law governing relations with Indigenous people are focused more towards preserving the status quo. And I was curious to know, what did you think about the reparations that were to be made towards these people for this genocide that they acknowledged? I know that there was a pecuniary settlement, but I wonder if an act of genocide would require more than just compensation, especially the kind of genocide that Canada owned up to. So I guess the question is more centered on reparations than anything else. Thank you.
Thank you very much.
Thank you. Sorry. Okay, and the Canadian recognition of the cultural genocide has been in two contexts in particular by the federal government. One of those being in the context of the residential schools policy, where Indigenous children were removed from their communities and taken into essentially boarding schools over a period of time, and there were various abuses committed at those residential schools. In response to that, there was a Truth and Reconciliation Commission and a series of compensation mechanisms for individuals that were affected by that. It wasn't treated as much as a genocide, although that was one of the terms that was used by the Truth and Reconciliation Commission. The other context where the federal government in Canada has made that comment is in the context of an ongoing issue concerning missing and murdered Indigenous women and girls, and there was an inquiry into that. And this is a case where there are disappearances or murders of individuals that often are Indigenous women or girls. The inquiry suggested that there were larger systemic policies at issue as opposed to just policing policies. And the government has spoken of that in terms of these terms of genocide. I'm not sure that they actually mean that seriously, insofar as they haven't taken the steps that one would expect if they were actually recognizing a genocide. I think that would be the 2022 comments would be around the missing, murdered Indigenous women and girls inquiry, although the similar language has been used with the residential schools. With the residential schools, there has been compensation. With the other, there's a bit of talk of policy changes, but there's a bit of argument in Canada about the tendencies of the current federal government to use terms that have a really profound significance in international law in terms of prohibitions on genocide, but then acting as if they don't believe the terms that they've used. Because as the question suggests, if they are suggesting that a genocide has occurred, there should be much more far-reaching steps taken, and it should be one of the very urgent things that all government action should be directed to stopping that genocide. So there's a complicated way in which that rhetoric is being used in Canada, and where the government seems to be using that terminology, but may not mean what it's actually saying. And it's a very messy situation in some respects in terms of how the government is using that language, but then not acting in accordance with the legal meaning of those terms. So I am actually struggling on how to answer that in terms of the government admission that should lead to much more action as compared to what we're seeing. So I maybe just leave it at that.
Okay, thank you very much, Prof. Newman. Is it all already clear, Dylan?
I think so. I mean, maybe it was an unfair question. So I understand it's a difficult solution.
I think it's a very fair question. I mean, when the government uses those terms, there should be very significant consequences that attach to that. But it's unclear whether the government actually means the terms that they use, honestly. So that would be my reaction to some extent. I think some of the officials in the Canadian government are not carefully considering the terms that they use.
Okay, thank you very much, Prof. Newman. It's all already clear, right, Dylan? Okay. Next to the question from Rahman Ditsa Twinindita. Okay, it's already here. Okay, time is yours. You can ask the questions.
All right, thank you very much. Good afternoon. My name is Rahmadin Sadwin Indita from Adat Law IUPA. I would like to ask a question to Mbak Sartika. Mbak Sartika, I heard some definition that you use in the presentation, which are indigenous and outsider. And I would like to ask out of curiosity, but my questions are quite long, so I hope it's clear. For the first one, is the definition of indigenous people in Indonesia simply translates to those whose ethnicity descent is originated from Indonesia, or is it narrowed by contextualizing it to the respective area of dispute? And if the definition translates to the first one, are so-called indigenous people who already adopt modern lifestyle, for example, in Jakarta, are still constitutes indigenous people? And to continue on that, what is actually the definition of outsider in Indonesian adat law? And my last question would be, if the definition of indigenous translate to simply those whose ethnicity descent is originated from Indonesia, since the majority of people in Indonesia are still indigenous, isn't it more relevant to create a law that protect those whose ethnicity descent is not originated from Indonesia? For example, the Chinese Indonesian descent, since there are still discriminations to be held upon them. So it's out of my curiosity. I hope you don't mind to answer them. Thank you.
Okay, thank you very much for Rahmadinsa. It is very interesting questions about the definitions of indigenous people in the Indonesian context. So first of all, I want to say that basically in the Indonesian context itself, we don't use the terms indigenous people, but we use like the terms in the 1945 constitutions. We know what we call as masyarakat hukum adat. Meanwhile, we also recognized what we call as masyarakat tradisional. That's also protected by these constitutions. And now we will see what is considered by the masyarakat hukum adat. So we just simply translate the masyarakat hukum adat with the indigenous people. Although there are also like debates whether or not it is correct when we just simply translate indigenous peoples as masyarakat hukum adat. But for short, we will just use the term masyarakat hukum adat in the context of indigenous people. So when we are talking about the definitions of indigenous people in the narrow sense, especially in the context of dispute areas, if we talk about masyarakat hukum adat or the indigenous people by the theory or by the history, we see that according to the theory, there are several classifications of indigenous people. So indigenous people who are living together based on their territory, based on their kinship or hereditary, as well as based on the hereditary as well as territory. Meanwhile, in the Constitutional Court decisions, it add one more like classifications, which is functional indigenous people. So they gather together because they have particular functions to conduct together. The example is Supa in Bali, or this is irrigations of the rice field in Bali. So the community of the irrigations community in Bali does not necessarily they are coming from the same indigenous people territorial community or indigenous people hereditary. They not always coming from the same heritage descendant or the same territory, but they are considered as indigenous people because they are doing the same functions in administering the irrigations. So that's one of the newest decisions from the Constitutional Court. So now we see that the definition of the indigenous people itself, we can see from several perspectives. And legislation in this context is only one of them. And in the context of the legislations, most likely we are talking of the indigenous people, which has the territorial indigenous people. Why then it is important to manage the territorial indigenous people? It's related with what I've just explained about the basiking reh or the ulayat rights or the rights towards their territory. But when we are talking we are talking about the indigenous people, especially what you call as modern lifestyle. We are not only talking about the indigenous people in the context of territorial. Like we see that probably here the Bataknis people from Batak community, people from Bali, people from Minangkabau, though they are modern now, like we are using gadget, and then going to the university. So like basically there is no such differences between indigenous people. Because indigenous people in Indonesia as well as Indonesian citizens. And by with being the indigenous people, they are still living based on their kinship matters. For example, Batak people living in Jakarta, though they have been modern, it's highly still forbidden for example, a Harahap girl will marry a Harahap man. Right? Or in the context of, for example, in Minangkabau, a Minangkabau girl or a Minangkabau man will be strongly prohibited to marry a Christian boy or a Christian girl, as well as in Bali. Someone who will get married will be questioned. You are married or you are marrying the same person with the same background or different, same ethnic or different. Those kind are still matters in the context of private adat law. So in the context of private adat law, in the sense of marriage law, inheritance law, just because you are being modern, like living in Jakarta, living in a big city, those things are still bound to the indigenous people in the context of kinship relationship. We can also see some court decisions about the rights of women in Batak or in the patrilineal community. They can have the rights of inheritance. Meanwhile, in the context of their traditional rules, it's prohibited. So we see that in that context, we can see the practice of being insider or being outsider matters. Even where, for example, a girl was born from a father from a matrilineal family, she is or he is not part of the matrilineal family of the mother community. Why? Because according to the matrilineal family, only the son or the daughters from coming from the mother, because the mother is the one who can pass the lineage, and those kind of things still happens. So when we talk about outsider or insider, it's not only because you live in particular territory, but we also questions you are part of which kind of kinship, and kinship will be will be traced based on patrilineal, matrilineal, or parental, and that still matters. So when we talk about ethnicity, like your last questions, basically when you asked about being Indonesians was just born in 1945, and before what we called as Indonesian nation state, the Chinese people, like the First Nations people, like we call this in Canada, they already been part of living in the what we call this in the territory which we call as Indonesian today. So when we talk about the minority, the discriminations, and then the unjust treatment towards those people, when we talk about those things, basically, indigenous communities is only one of them. But what happened with the indigenous community is not only happened within the indigenous communities itself. It's also happened with the other operations activities with the less powerful people, as well as like the Chinese. And then in the context of Chinese, like you have asked, during the colonial period itself, they are considered to have their own law. So it's considered have different law. So basically, what I'm going to say is legal pluralism exists as in the context of public law, like the like for example identity card or the rights to vote, they are the same. But in the context of the private law, we can see there is variations, like the marriage law, the inheritance law. It might differs from one ethnic groups to the different ethnic groups. But in the context of as a nation state, then those minorities, if being oppressed or being unjust, so in the context of indigenous people movement, that's actually with the same spirit as well as with the farmer movements or any other movement which asking for the justice towards their rights. Am I answering your questions, Rahmadinsa?
Yes, but I would like to have some follow-up questions if that's okay.
Yeah, sure.
My follow-up question would be, since masyarakat hukum adat am I using the right term, Mbak?
Yes.
It's not directly translated to indigenous people, right? So are we still gonna say indigenous people in the context of using English language, or still just use masyarakat hukum adat as it is as terminology? And yeah, I think that would be it.
It depends. If like in my English paper, usually I will explain that most likely indigenous community will be translated in bahasa as adat law, as masyarakat hukum adat. But then I also often use the terms to make this in the Indonesian context. So I will just introduce that indigenous people in the context of Indonesia is adat law community. So for this paper, then I will just write the indigenous people in Indonesia as adat law community. So I do not translate the indigenous people as adat law community. But sometimes also it's okay to use the terms indigenous people, but you can also put like footnote that in Indonesia, it's often called as masyarakat hukum adat or adat law community.
All right, thank you very much, Mbak.
Thank you very much, Mbak Kaka and Rahma. I think it's really reminds me a lot about all of these questions when I was also learning at the first time about the topics. Okay, so as we already gained a lot of answered and ideas and insight from the question and answer, once again, I want to remind all of the people in here, all the friends in here, if you want to ask directly, you can ask. Or if you want to direct message me first, if you're a little bit shy, you can direct message me. Okay. For the next question, we already have one person, Zavanya. Zavanya, are you already prepared?
Hi, yes.
Okay.
Yes, I'm here.
Time is yours, Zavanya. You can ask.
Thanks. Thank you. Good afternoon. My name is Stefania, and I would like to ask a question, maybe more specifically towards Indonesian adult law, but if it could be relevant for the Canadian Indigenous people protection, then that would be great. So my question is for Mbak. I'm curious about what about in the case of Indigenous people or specific tribes in a territory in Indonesia that is being dominated by a settler from another territory also in Indonesia? Because we know here in Indonesia, it's pretty normal for people to move from one area to another and settle there. But then there are cases where most of the people in that area are displaced by a new tribe. For example, like Suku Betawi in Jakarta, which is now being dominated by other tribes such as Japanese or maybe Sundanese, and it's being slowly displaced. Is there a protection for them, maybe specifically in terms of their land right, or would that not fall under the protection of Indigenous people or adat law in Indonesia? I'm not sure about the relevancy of this question or situation in Canada, but if it exists as well as an issue, how's it being handled there?
Thank you very much, Zavanya. Okay, Mbak Kaka, you have time first to answer this question.
Okay, very interesting questions. So, if there is adat law community or the indigenous people, previously they are living in one region, and then some other tribe will coming to that place, and then they become dominant in this area. It happens a lot, like in Kalimantan due to the transmigrations, and then now there is new capital city in Kalimantan as well. That's another story. So that's basically similar questions to along with the Proyek Strategis Nasional, if there is strategic government policy, to what extent then the rights of indigenous people shall be protected. So Zevanya, we should come from a case-to-case basis. But general principally speaking, like what Professor Dwight have just mentioned, that there is the principle of free, prior, and informed consent. So how then the people were coming to the new area? If, for example, they are coming because of buying and selling land with the member of the community or through the marriage, I believe that such coming will not be like problematic. But it will be more likely problematic because, for example, in the Indonesian context, the history of transmigrations, when the local people were never like being asked if how large is your territory, and in particular part of the territory there will be new people. So we should like tracing back how was the people coming at the first place. Because when we see like in our research in East Nusa Tenggara, there were cases where, for example, because there is flood, there is natural disaster, for example, because there is like at this current situations, like we just had COVID-19, so there was a case because of suddenly the land just extinct or severe illness of the people in particular regions, so they have to move to the other regions. But how they moved, the history or how they moved will make us understand the legal relationship between the newcomer as well as the old people living there. And it can be very complicated, even very difficult solutions once the moving is not because of like voluntarily movement, because such of occurrence or marriage, but because of operations. So there is a force from the one which is very strong, like the government. So if that kind of things happen, the analysis is not only like we analyze in the context of law, but if also in the context of politics. How then law being used to, for example, smoothen the process of oppressions. Therefore, the people living in the local regions cannot against which such decisions. So from your questions, then we can see from the case per case basis on how such movement happens, and then from that, then we can see what are the rights and obligations from each of the participants and who are the agents or who are the parties involved in this. If there is like very unbalanced power positions, it may also be very difficult for the local people to fight for their rights towards their territory. We are not talking yet about the economic factors, as well as, for example, there is certain things in the international level that also can make things different. Like in the context of Rohingya, they are coming to Indonesia. It's not because of operations, but they are being oppressed in their country. Then they look for protections in our country. So that's my answer. Am I answering your questions, Zevanya?
Yes, thank you, Mbak.
Okay, thank you very much, Zevanya and Mbak Elva. I think as these friends and students already give me a private chat and have some other questions, let's move for the next question. Okay, I note in here from Alvinka. Is Calvinka already prepared for the camera and mic? Okay.
Good morning. My question primarily is to Mbak Kaka. You mentioned earlier in your presentation about sort of how customary law is, like how it started in Indonesia, the recognition, and how now it's been codified even to the Perdes level, district level. Maybe I just want to ask for clarification purposes. We know that in theory and in reality, the law expresses itself differently. And in theory, it's nice to have codifications in all the different levels. But in reality, we still have some cases where there's still tension between the position of customary law, adat law, as well as state law. And often state law is favored and we have customary law marginalized. And in theory, customary law is like specialist. So I wonder, what can we do as, law students, but also after we graduate, what can we do to better the system so that it's not just by theory, but we actually, do something about the law? Yeah, because we have cases where it's like big corporations and you have, for instance, I have an example. Give me a moment. The Savo people in East Nusa Tenggara, and you also have the land boundaries that they have, but it's also in conflict with the state law, what it says. And we also have, for instance, expansion of oil palm plantations with the Kinipan indigenous people and how that's also in conflict. So I just maybe wonder, what can we do to better that? Thanks.
Okay, very good questions, Calvinka. So she comes from the actual case happened in Indonesia, especially with the adult law communities, with the plantations company, as well as with the oil company. So what happened? So I want to clarify first that when we are talking about indigenous law or adat law with the state law, it's not like specialist, Calvinka. Like specialist is for the positivistic approach. So we do not say that adat law is like specialist in the context of state law, but we see this from the perspective of legal pluralism. So there is an interesting paper written by Adrian Bettner. So Adrian Bettner just comparing the legal thought of Van Vollenhoven with Malinowski as well as Eugene Ehrlich. So the imaginations of being Indonesians, how then legal pluralism can exist. Unfortunately, when we become one of the nations, a republic, a state, we made like the written law with the positivistic approach, of course, with its hierarchical system. The question is how then we can change, whether we can remove all of the colonial law and then change directly with the adat law or the indigenous law. And the answer is, of course, not. Why? Because many regions have much more different law. So how can we like upscaling the local level law in the level of national law? The answer was to use the positivistic approach towards adat law. So this is also my paper as well as Pak Ricardo paper on how the state administrator using the adat law. The first is they can refer to what we call as general principle. So for example, in the context of land transactions, general principle is there should be witness. There should be exchange goods or money. So general principle are applied in the in the worldwide Indonesia. Does not necessarily comes with the specific norms which might be different, but the general principle applied generally. So that's the first on how to upgrade the level of applications of the indigenous law or adat law. And then the second, whether or not then we should like codify the indigenous people law. I don't think that it's still relevant questions because the fact we already have so many local regulations regulating the rights of indigenous people as well as recognizing the law of the indigenous people. The interesting thing is if we think that after the indigenous people law is being regulated by the state, it will change the authority from the indigenous people to the state apparatus. But the interesting thing is the state law, the local regulations, they recognize the rights of the adat functionaries or the indigenous people functionaries of their rights. So for example, there is a regional regulations which recognize the rights of damang or functionaries adat in middle central Kalimantan to issue land, like a kind of land title. So it's interesting that the state also recognized the authority of the adat functionaries or the adat organizer. As well as in Minangkabau, the state also recognized the authority of kaum, the authority of nagari. So when we talk about how then and then that's still in the legislations, even in the constitution, even in the court also recognize the rights of indigenous people as well as the indigenous law. So from my research, I found that the court also refer to the indigenous law, which has been regulated in the legislations. And then the court also refer to find the law in the concept made by the legal scholars as well in the legal principles. So it's interesting how today we see that the state apparatus also like revering the law, not only the legislations like which about the state law, but also the legislations which also regulating about the adat law, as well as the court itself referring to the general principles or concept made by living within the community or made by the legal scholars. So here we see that basically legal plurality is our reality. We see that in practice, state law is not that it's not like the only things applicable within the community. We see that when people struggle for what they believe as their rights, actually at that point we see that there are other rules working within the community. So instead of seeing conflict as conflict, we can see also that in the conflict, people are state their arguments. And their arguments depends on how they understand about the fact. And how they understand about the fact does not necessarily only the fact which understood by the state law, but also the fact that they understood about the legal rules working in their daily life. And these rules can come from the adat, can come from the religions. So during the conflict, it's a very good opportunity for us as legal scholars to see what actually working, what rules are actually working within the community. And second, what I want to talk, when we talk about law, remember law has purpose. So only only practicing implementing law, it's just a skill. And law as a science, also not only legal skill, but also like if for example, law always have interest, law always have purpose. So the question is, once law being made, once law is implemented, it will bring benefit. It will serve to the favor of whose interest. Now, at that point, you, us as legal scholars, have to be more critical. And as Professor Dwight have just mentioned, has to hear so many different perspectives. So at that point, we can bring the law, we can make the law, we can enforce the law which serve the justice of the people, the utility of the people, especially those like Rahmadin have just asked. If there are like many people, so intersectionality is very important for us to understand by the applications of particular law who will have the most benefit and who got the most severe consequences. And at that point, as legal scholars, how us where law has the desires to uphold justice, how can we bring justice with this law? If this law is not consistent with the idea of justice, then what kind of law which we should develop? So I think that's how we should learn and how we should later on when we practicing, we not only just implement what the law says, but we see deeper. This law serve whose interest? And when we implement the law, who will get the most benefit? Whether those people like Rahmadin Shah have just mentioned, who suffering social situations, are they could benefit from this law? If not, don't implement that kind of law. Find the other law. There are so many sources of law. So remember, law is not just what the law says or the norms. It's also about ethics. It's also about values. It's also about how the people are living by their rules or regulations. Am I answering your questions, Calvinka?
Yeah, thank you, Mbak Kakak.
Thank you very much, Mbak Kakak and Calvinka. It's really insightful question and also answer. I think lastly, we have one more last question for Professor Newman. The question from, excuse me for a while, Ramadhani Nicholas.
Okay, good afternoon, Mbak Kakak and Mr. Dwight. I'm sorry, I'm unable to turn my camera at the moment due to some issues, so I'll continue the sessions off camera then. Okay, my name is Ramadhani Sugianto Nicholas from Class A of Hukum Adat dan Perkembangannya. I'm intrigued by the comparisons of regulatory evolutions concerning indigenous people in Canada and Indonesia. And I like to ask Mr. Dwight Newman and Mbak Kakak questions like, how do they integrate historical dynamics of colonial settlements by various European powers like the French and English for Canada and Dutch for Indonesia, shape the legal framework of indigenous rights in both Canada and Indonesia today. Gitu. That's enough.
Okay, thank you very much, Ramadhani. Okay, maybe the first answer would be can come from Professor Newman.
Okay, it's a very good but very big question of how the colonial history and the dynamics of that shapes Indigenous rights in Canada. I would say that in some ways, how it shapes it is by creating the issues that are to be overcome, and those end up being slightly different in Quebec with a French colonial history versus in other parts of Canada with an English colonial history, because the English, upon taking control of Quebec, allowed the ongoing maintenance of property rights under the previous French law system. And so Quebec law is based on civil law, and the scope for Indigenous land rights is different there than in English Canada in some respects. So that's one way in which the colonial history shapes matters, is the way in which Indigenous land rights got excluded is different in different parts of the country, and how the responses are going to work to that has to function in the context of two different land right systems. And then there are some further complexities that in terms of different land right systems within other parts of the country within a general common law framework. But I'll leave that aside and just say that's one difference. I guess the particular attitudes passed on within different colonial systems have had different effects on Indigenous rights. But just generally today, the response is also shaped partly by those colonial systems. And so, for example, when I mentioned that the common law in Canada had been able to start developing a way of recognizing Indigenous land rights even before the constitutional change in the 1970s, well, that was part of an international development in the common law. And in other countries like Australia, Malaysia, others, there are bits of that jurisprudence around common law Indigenous land rights. And so the same colonial system that was an oppressor can start to try to overcome that. Those would be just some responses at a very broad level, but the question's a big one, and sort of the historical dynamics more generally have to include the shift towards things like the adoption of a constitutional Bill of Rights in Canada that also then has attached to it an Indigenous rights provision, and the attitude of finally taking up obligations under international norms in relation to the United Nations Declaration of the Rights of Indigenous Peoples. Well, there's parts of the colonial system that push towards that over time, but it's been the oppressor, and it now is working to overcome that. I guess would be my general way of responding to what's a rich and complex question.
Thank you very much, Prof. Newman. I think it's really give a lot of insight for the question, and maybe Mbak Aka would add some points.
Okay, Ramadhani just got the point that understanding the history will help us a lot to understand our current situations. And what Prof. Dwight Newman have just explained, the current situation is Canada. We cannot separate that from the history, as well as Indonesia's current situations. We cannot separate this from the history. But in the context of Indonesia, I can suggest several reading materials. How interesting that the first you can read Kartini, panggil aku Kartini saja, Pramudia Ananta's book. Yeah, in one side, like during the colonial era, it brought the operations in one side, but also it brought because when we talk about operations, Dutch colonial government might be also only one of them. In the context of the community themselves, there are practice of feudalism also. So how then, for example, in the context of women movement, the influence of socialist group in the West also helps women to access for education, for example. So that's also I don't know whether we can say that one of the good things we learn from the West practiced on how they uphold the rights of the women, for example. But in the context of rights over the land, you can read Eti Iksan dissertations. It was very good, which it can explain how maybe I can say that in the context of colonial government, although in the context of tanam paksa, there is an obligations or mandatory cultivations. It was very bad for the East Indies nations at that time. But in one case, at that time, it is prohibited to transfer land title in the context of indigenous people land title. So the land can be leased for 90 years. But unfortunately, in the context of today, Indonesia independent, for like Lang have just questions in the first questions and answer sessions, the regulations oblige the indigenous people to hand over their land. So it means that in the context of indigenous people land ownership, maybe the protections on the indigenous people land, can we say that it's better at that time because it's prohibit the land transfer in the context of land utilizations by large company. Meanwhile, at the situations like kind of cooperations is still being discussed, especially when we talk about theoretically speaking, it's possible the adat law community or the indigenous people to have cooperations with the third party. But unfortunately, since their land are considered as state land, they do not have rights over their territory. That's why then they cannot make cooperations because they are not considered as legal subject. So the question is how then we can strengthen their authority towards their territory, therefore they can exercise their territory for their benefits, and that's quite different with the practice of the colonial time as well as in the current situations. So in the context of like being civil law, yeah, we are highly influenced by the Dutch, but the perspective on how we protect the indigenous law, we still have to be criticized, whether or not now in the current situations we have this adequate protections can really bring justice towards the indigenous people, not just being more bureaucratic, giving more bureaucratic agenda for them to administer their land or to register their rights. Okay.
Thank you very much, Mbak Kaka. I think it's really good answer from both Professor Newman once again and Mbak Kaka. And I think it's already wrapped up all of the time for the question and answer since the time already running out. But before we conclude and we have a closing remarks from Professor Newman and Mbak Kaka, I would ask first for Mbak Kaka to give a little bit about pengumuman or anything based on maybe information that needs for all the people and the classes for today. Mbak Kaka?
Okay, so thank you very much, Indra. So I will just to inform of the students here, especially from the class of Hukum Adat dan Perkembangannya, as well as Adat Law Introductions and Selected Issues. Make sure that each of you has joined ELOC, and then there is already a quiz for you, and the due dates is next week meeting. So make sure that you join ELOC and then work on the quiz, and then you can also read the course outline. Thank you.
Okay, thank you, Mbak Kaka. Please everyone note that information. And we finally will close our seminar with the closing remarks from Professor Newman and also Mbak Kaka. Maybe first, I will give the time for Professor Newman to have closing remarks.
Okay, I'll just conclude very briefly and say that we've found some significant shared themes in terms of the interaction of Indigenous rights with the history of places. And that's something that makes for complexity in how we address Indigenous rights today. We can't talk about one simple solution identical, but we need to talk about solutions that respond to particular colonial histories and that respond to the aspirations of Indigenous peoples in their particular circumstances. And that's the general principle that's encouraged by something like the international norms on Indigenous rights, but we need to understand them in their contexts. And I think I've had my thinking enriched by our discussion, so I appreciate the chance to be here and to have this sharing between us. And I'd also commend all of you here who are here as students for your work that you're going to do in studying adat law and thinking about the rights of Indigenous peoples in Indonesia. I think that you're undertaking very important work for how to pursue a more just world. And that's something that we should all be thinking about throughout our legal studies. So I'd just end there and thank you for having me participate in the class today.
Thank you very much, and give a really big applause for Professor Newman. It's really good closing remarks and statements. So it gives us a lot of conclusion about what should we do as future lawyers and students and academic. Okay, the next closing remarks from Mbak Kaka.
Yes, thank you very much, Indra. We are very grateful to have you, Prof. Dwight Newman, for this opening class. I hope it can wider the understanding of the students that the issues of Indigenous law, Indigenous people is not only locally in the context of Indonesia, but also has international perspective from the different practices in different nations. And for the informations that the unit of research and publications will issue students research, and from Joyodikuno Research Center or the Adat Law Research Center in our school, we will offer one of the issues is comparative land registrations from one state to another. So might be, if you are interested, you can use the perspective of the Canada, like Professor Dwight Newman have just mentioned. Different states might have different law as well, different approach on how to settle the case. That can be an interesting issues to be discussed if you want to follow up our discussions today with further research. So I'm also grateful that from this meeting, I hope next we can have another occasions when we can share our experience, as well as maybe we can then think what will be, for example, the best solutions, like what you have said with this kind of complexity, then what kind of approach we can learn from Indonesian practice as well as Canadian practice, and maybe then we create another sessions from this. So I'm very grateful, Professor Dwight Newman. Thank you very much, as well as Indra for moderating this class. It runs very well, and also for the participations of the students. You are very enthusiastic and the questions are just amazing. Thank you very much.
Thank you very much, Mbak Kaka. Okay, everyone, before I give a closing remarks for the whole seminar, I want you guys in here to just turn on the camera for us to a little bit have a documentation and also showing the presence of all of the students in each classes. Can everyone turn on the camera so we can take photo? I will count 10 until 1, so everyone prepare. 10, 9, 8, 7, 6, 5. Please everyone turn on the camera. 5, 4, okay. 4, 3, okay. Everyone already turned on the camera. Okay, there is 7 slides. Okay, let's take photo first. From the first slide, I would say 1, 2, 3, and I will capture it. Okay, 1, 2, 3. Okay, next slide. 1, 2, 3. Next slide. 1, 2, 3. Okay, last 3 more. 1, 2, 3. Okay, good. Okay. Thank you very much for everyone that already spent a very, it's still kind of holiday, but I have a time at home to study. But once again, I would say thank you, and I hope it's conclude all of the curiosity and the topics and all materials that we interested to join. But as I can write and notes, I can conclude that our seminar today reflects or in light our journey that we shared through the Indigenous people rights protection as we first traverse the rich Indigenous histories and colonial place of Canada and Indonesia, and how it makes us understand their impact on the present time Indigenous community rights and protection. And also the seminar unpacked the complex relationship between the state and Indigenous laws, highlighting the need for the harmonious coexistence. Also, we grapple with the intricate balance of acknowledging traditional rights within the scope of modern legal system, and we discuss emphasizing the importance of legal recognition and protection of Indigenous rights, drawing from constitutional commitments and evolving jurisprudence. Lastly, the role of education is really important in shaping future advocates for Indigenous rights was underscored, emphasizing the need for the informed legal community. And one really good quote from Kaka, also from Professor Newman, as we close, remember, law is more than text. It's the embodiment of values and ethics, a reflection of how Indigenous people live with the land and with one another. Law's true purpose is to serve these communities faithfully, honoring their traditions and way of life. Let's take the spirit of understanding and respect into the heart of our practice. Thank you for everyone in here. I hope you have a great day, and I hope all of the materials and information, education is really grateful and useful for all of us in the future. Thank you very much for everyone. Thank you very much, Prof. Newman. Thank you very much, Mbak Sartika. Okay, for everyone, yeah.
Thank you.
Thank you, Mbak Kaka. Thank you, Prof.
Thank you.
Thank
Prof.
you.
Newman, if you don't mind, please send the presentations to me through email, then I will share this with the students.
Oh, okay. Sure. I'll do that.
I'll also send mine to you. Thank you very
Okay.
much.
Thank you.
Thank you, Prof. Thank you, Mbak
Thank you.
Kaka.
Thank you, Indra.
Thank
I
you
hope
for your moderating. Yes, thank you.
Thank you. I hope to see you in all other occasions.
Okay. Bye.